Hello, and thanks for watching another edition of ARFCOM News. Today I want to tell you about the first Supreme Court gun case in over a decade and the feds who lied to get a warrant, plus lots more. But before we get started, I want to tell you about the fine mahogany night vision products with custom Corinthian leather trim offered to you by our friends at tnvc.com. Artfully handcrafted by earnest, hardworking Amish operators, TNVC Night Vision is unique and uncompromising, just like you. If you like seeing stuff more than not seeing stuff, take a look at our sponsor, tnvc.com, your source for quality night vision gear to make you the bump in the night. You may have heard the Supremes have deigned to hear the first gun rights case in over a decade. In 2008, Heller v. D.C. affirmed the right to bear arms is an individual right independent of malicious service. And in 2010, McDonald v. Chicago incorporated that right into the 14th Amendment. That is to say, it affirmed the Second Amendment prevents states, not just the federal government, from infringing on the right to bear arms. But Heller was a somewhat narrow ruling, and strictly speaking, it only applies within the home. Obviously, any sane person can see the founders didn't intend the bearing of arms would be limited to the home any more than they intended the right to worship as you please would also be limited to just your own home. So New York State Rifle and Pistol Association versus Corlett might just settle that question. Or at least it could if the court were to consider the question as it was presented by the United States Petitioner General Paul Clement. As he stated it, the question presented is whether the Second Amendment allows the government to prohibit ordinary law-abiding citizens from carrying handguns outside the home for self-defense. But the court has rewritten that question, and now it reads whether the state's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. So the big thing which really jumps out here is it looks as though the court is focusing on whether the denial of permits was constitutional, not whether the existence of a state permission slip is constitutional in the first place. But as Josh Blackman points out on the Volokh conspiracy, if they only wished to examine the denial of the permit, one would expect them to be looking at due process under the 5th and 14th Amendments, not the Second Amendment. And it's also worth noting the court rewrote the question presented in Heller as well. It's possible this case could result in a ruling on the bearing of arms outside the home in general, but it is also possible it could relate solely to the issuing of permits. In my entirely lay opinion, a strong possibility is the court finds the permits to be acceptable, but discretionary processes to be too burdensome. In any case, it's likely to be a solid year before we have an answer. What do you think? What will the scope of the ruling be? Oh look, the feds lied to get a warrant. This is my shocked face. John Andrews Jr. bought a Chinese solvent trap, and federal agents claimed it was a silencer in order for West Seneca police to get a warrant to search his home. When they did, they found 8 guns and charged him with felony firearms possession because Andrews has a misdemeanor on his record, which would disqualify him from owning guns in New York State, except he says he has a certificate of relief from the court restoring his gun rights. But here's the fun part. None of that even matters because a state Supreme Court judge threw out all the charges when he found the cops lied to get the warrant. You see, solvent traps may look like silencers, but they aren't. At least not without some machining. And it is perfectly legal to own solvent traps so long as you don't do that machining. So with the search warrant invalidated, everything produced by the warrant has to be thrown out. Fruit of the poisonous tree and all that. Nice to see a happy ending for once. Defense Distributed has been involved in a long, drawn-out fight with the U.S. State Department and multiple state attorneys general for years over the right to disseminate 3D gun files on the interwebs. Just as the State Department was poised to settle the case, the AGs stepped in and sued for an injunction to stop Defense Distributed. This all might seem rather pointless to you because it's the internet after all, and you'd be right. All the files in question are widely available to anyone with the inclination to find them. But this is about principle, damn it, and about whether Defense Distributed can legally work its mojo. Thankfully, the Ninth Circuit vacated the decision of the lower court to issue the injunction a few days ago, leaving DD free to distribute defense again, at least until the AG's appeal for an en banc review. This man has the raddest coat in the nation. He also used to have a pretty nice truck until the United States government stole it from him anyway. In 2015, Gerardo Serrano was taking photos near the U.S.-Mexico border when CBP agents stopped him and searched his vehicle. After finding 5 loose rounds of ammo, which they declared to be munitions of war, even though he didn't have a gun, they seized his truck, questioned him for hours, then released him to walk home. He was never even charged with a crime, and the CBP refused to file a formal civil asset forfeiture complaint. After 2 years of fighting with the courts, Serrano eventually hired an attorney and sued the CBP on due process grounds, at which point they finally released his truck. So that's cool, I guess. But recently, the Supreme Court refused to hear his case, which sends the message that law enforcement agencies can arbitrarily seize a person's property on something as flimsy as a handful of legally owned rounds, and then refuse to grant any sort of appeal or process indefinitely. How do you folks feel about that? Should police be allowed to seize property without a conviction? Should they be allowed to sell that property and keep the proceeds? Comment below. Well, friends, that's all I have for you today. I hope you enjoy watching these things because I sure like making them for you. You guys are always asking me where I find my fly shirts, so this time I put a link to my shirt down there in the doobly-doo. But if you'd like to try your luck and see if you can win this rad shirt, post a comment containing the phrase 96 tears and 96 eyes in the YouTube comments, and I will arbitrarily and unilaterally choose the best one. If you would like to help us keep bringing you banger content like this, please support the folks who support us. Not only does TNVC.com give you night vision with that cool, refreshing, never bitter taste that goes down smooth, they also have mounts, lights, and all sorts of other gear to make you the bump in the night. I love you.